Chief Val Daniels here with a lesson on California Penal Code Section 245A. 1. Assault with a deadly weapon, which we commonly refer to as ADW. The corpus delicti for this crime is found in the statute and jury instructions, Cal Crim 875. To prove that the defendant is guilty of this crime, the people must prove that 1. The defendant did an act with a deadly weapon that by its nature would directly and probably result in the application of force to a person. Or, the defendant did an act that by its nature would directly and probably result in the application of force to a person, and the force used was likely to produce great bodily injury. 2. The defendant did that act willfully. 3. When the defendant acted, they were aware of facts that would lead a reasonable person to realize that their act by its nature would directly and probably result in the application of force to someone. And 4. When the defendant acted, they had the present ability to apply force likely to produce great bodily injury. And 5. The defendant did not act in self-defense or in defense of someone else. Someone commits an act willfully when he or she does it willingly or on purpose. It is not required that he or she intend to break the law, hurt someone else, or gain any advantage. No one needs to actually have been injured by defendant's act. But if someone was injured, you may consider that fact, along with all the other evidence, in deciding whether the defendant committed an assault, and if so, what kind of assault it was. Great bodily injury means significant or substantial physical injury. It is an injury that is greater than minor or moderate harm. Examples of great bodily injury include broken bones, gunshot wounds, dog bites, and lacerations. A deadly weapon is any object, instrument, or weapon that is inherently deadly, or one that is used in such a way that it is capable of causing and likely to cause death or great bodily injury. An object is inherently deadly if it is deadly or dangerous in the ordinary use for which it was designed. In deciding whether an object is a deadly weapon, consider all the surrounding circumstances. There is no crime of attempted assault in California. In Re James M. 1973. An assault is an attempt by its very nature. If you actually strike someone, it becomes a battery. Assault is a lesser included crime of battery. For example, say Jovina, not her real name, swings a baseball bat at her neighbor in anger, she could be charged with ADW. She acted willfully, the bat was potentially harmful, and she had the present ability to cause great bodily injury. Common defenses to this crime include, you acted in lawful self-defense, the object was not a deadly weapon, or your actions were not willful. For example, Jovina is playing softball and accidentally lets go of the bat while she is swinging at a pitch. The bat sails by another player. There was no criminal intent in this scenario, and she would not be charged with a crime. I'm Chief Val Daniels, and that was your lesson on California Penal Code Section 245A. 1. ADW.